This week, a Ugandan law student was arrested for sharing a court document online. That's right. Gloria Grace Laker is currently on remand, but here is the legal question many people are asking. If court proceedings are supposed to be public, how does sharing a court record become a criminal offense? I am Butanda Shafiq, and today we are breaking this down. First, here's what we know. On March 13th, Laker appeared before the Gulu Grade 1 Magistrates Court, where she was charged under the Computer Misuse Act. Prosecutors say that between March 6th and March 9th, she shared a page from a court file related to opposition leader Robert Kyagulanyi Ssentamu, also known as Bobi Wine. Laker pleaded not guilty to the charges. However, her bail hearing was pushed to March 17th, meaning she has been remanded to Gulu Central Prison in the meantime. Now here is where it gets interesting. This case has sparked debate because of something called the open justice principle. In most democracies, including Uganda, courts operate in public. Hearings are usually open, journalists can report on them, and many court documents, like charge sheets or entries in the criminal register, are generally not considered secret. And this is where lawyer Aaron Kiza enters the conversation. Kiza argues that the criminal register is a public document containing public information. And since the person mentioned in the document, Robert Kyagulanyi Ssentamu, is also a public figure and leader of the National Unity Platform, he believes sharing that information should not be criminalized. In his view, prosecuting someone for sharing such information risks undermining transparency and freedom of expression. But there is another side to this. Even if court information is public, there are still procedures for accessing and distributing official documents. For example, copies are usually obtained through the court registry, sometimes with authorization or certification. So authorities may argue that the issue is not the information itself, but how it was obtained and shared digitally. And that is where the Computer Misuse Act may come into play. So the real question becomes this. Where should the law draw the line between protecting court procedures and protecting the public's right to access information? Because courts are meant to be transparent institutions, but they also maintain rules about how official records are handled. And this case may end up testing how those two principles interact in Uganda's legal system. For now, Gloria Grace Laker remains on remand as the case continues. But her situation has already triggered a wider conversation about transparency, digital communication, and freedom of expression in the age of social media. So let me ask you this. If a court document contains public information, should sharing it online be considered a crime? Or is it part of public accountability? Let me know what you think in the comments. Until next time, I am Shafiq Butanda.